said, whenever this is, welcome. Hope everybody is well. I am expecting a guest shortly. That guest being JR. He should be here any moment. I think he was testing out cars with Trevor Milton today. Trevor Milton was the guy, by the way, who was accused of setting up some scam to roll his truck, his electric truck, to fool investors. And he went to jail, I believe, for fraud, securities fraud. I believe that's why he went to jail. And he was pardoned today by the administration. So not a big fan of that activity. I don't think fraudsters should be pardoned, but that's not really what we're going to talk about today. I'm kind of vamping here until JR joins us. What we're going to talk about today, and I've kind of done a couple of videos, actually live streams about this. We're talking about the Supreme Court and their recent hearing on a non-delegation case, how that might apply to Alpine and to FINRA and the SEC. That's kind of the general scenario. And I had planned to do that with JR before yesterday when I got notice that Alpine's expulsion that was issued in 2022 had been affirmed. So that changed kind of what we were going to talk about a little bit. It added to that. You don't mind if I take a quick peek. I'm looking to see when JR will be joining us, but so that kind of changed the analysis. So today we're going to kind of look at, based upon what FINRA did with regard to Alpine and that expulsion, how that impacts what the Supreme Court might do to Alpine, FINRA, the SEC, us, etc. And that's where we is. And so before we start, of course, this is not legal advice. Like, subscribe, share. Follow me at Not Legal Advice, ironically, KNOTLEGALADVICE, all one word. Please do so. And before I move forward, I had a couple things I wanted to. I wish JR was here for these, but so be it, for the jokes. But so be it, because they're such fine jokes. What do you call a parade? And this really applies to both JR and myself. That's why I wish he was here to hear this. What do you call a parade of rabbits hopping backwards? A receding hairline, obviously. And why did the chicken go to the seance? To get to the other side, of course. And last but not least, of course, how can you tell that you're getting old? You go to an antique auction and 3 people place bids on you. That's when you know you're really old. And that is it. I got a message from JR. I'm going to quickly check. Oh, he's here. I don't see him, though. So I'm going to correct a technical problem. We're having a little bit of a technical issue. I think JR thinks he's looking at the wrong link. Sending you new one now. So I always send him links whether he could appear or not. And for today's purpose, this is behind the scenes. This is high-tech stuff. Apparently, this is my guess, he's looking at a different link. So I'm resending him the link right now, as I do. And I did, and it is. And after that, I expect he will join us very promptly thereafter. So anyway, just to bring you up to speed, we're going to talk about that case of yesterday. I had watched it. And the name of the case is FCC versus Consumer Research. It was consolidated with another case involving the same issues, and it involved. There he is. There you are.
It's a crazy day. Totally crazy day.
I think what happened is just this is behind the scenes. Hi there, by the way. Behind the scenes, you missed the 3 jokes, by the way. Behind the scenes, I think I sent you like 3 different links.
You sent me 4.
Yeah, and you probably went to prior sessions, not the one today. So I blame you entirely. I'm not going to repeat the jokes. We're just going to kind of run into it. I was just about to kind of like frame it. So yesterday, the Supreme Court, yesterday or the day before, I don't remember which. I think it was yesterday, right? Yesterday.
Yeah, I'm still here. I had to stand up because the sun is beaming in. I didn't want you all to see my stomach. I had to close the blinds. Sorry.
I actually kind of want to see your stomach. So could you please stand up again?
I have a crop top on now.
Okay. Yesterday, the Supreme Court had a hearing with regard to FCC versus Consumer Research and a consolidated case. I looked at it. We kind of talked about it briefly, JR and I. I did a video on it. Then JR has seen it since then, I presume. And I kind of wanted to get his take on it. We would then talk about it, kind of put it in the frame of Alpine, MMTLP, FINRA, the SEC, and then kind of include what happened yesterday with how the expulsion of Alpine was affirmed and kind of how that might play in. So first, you got all that, right? All right.
Yeah. So I got about 3/4 of the way through, and then, as you know, when I pinged you, I got pulled into work, so I didn't get to listen to the entire argument, but I got a good bit of it. So
okay, so why don't you give me your impressions of it?
Well, I mean, you and I talked about this. You kind of said it was relatable. There was only a couple of points that stuck out to me that I thought, okay, this is usable. I mean, it seemed like, well, the first thing I noticed, and I think you noticed this as well too, the conservative side of the court appears to want to limit the executive branch and the government. That was my first impression. The liberal side of the court thinks, no, this is perfectly within the non-delegation clause, and it's okay. So that was my first takeaway. And
so when you're saying that the liberal side of the court would be okay with giving the regulatory body their authority, yes, right? And the conservative side kind of suggested they were interested in limiting the regulatory authority.
Well, I think interest is a light word. I'm trying to think I want to say, is it Alito? Justice Alito? No. Who am I thinking of?
Well, yeah, Thomas spoke quite a bit. And,
Thomas spoke quite a bit, but Justice Alito seemed to be the one that, for me, was, no, just a no. And he kept throwing hypotheticals out that, every time she'd answer, he'd be like, no, that's not it. Let me narrow it for you. So yeah. I definitely got the impression that the government is not getting his vote.
Yeah.
So,
and what did you think about the attorneys that you heard? The
well, attorneys I don't know who that was arguing on behalf of the government, but the woman that first argued, holy shit! I mean, she was just pulling. My God, they cited the whiskey treason of 17 something. and she was talking about it like she was there. Like she had her facts, she knew. Then they cited something else out of Allegheny County in the 1800s. She was just spot on. I was not impressed with the defendants' lawyers.
So that would be the lawyers that kind of would be representing us.
Yeah, I know. His whole presentation took 50 seconds. He's like, "Here it is. Do you have any questions?"
Yeah, my opinion, and I said it yesterday. I thought he sucked.
Yeah,
I did. Yeah. And again, there was another gentleman who. So it was a consolidated case. I think he was the attorney on the consolidated case. I thought he was pretty relaxed in his
I didn't. Yeah,
presentation.
I apologize, but I didn't get to him. So,
Okay. Okay. But anyway, I
but
agree
let
with
me
you.
go back. Let me go back because you asked where it's relatable. I struggled relating this case. I freely admit, and I struggled because they kept narrowing the issue down to the fees that were being charged, and what was the one hang up was on
No cap. No
the
cap.
the no cap, and then the significance of the technology. And
Yeah.
one of the questions, and I forget who the justice was, but he kept harping on it. What if this new technology
Yeah.
comes out? When do you where do you draw the line? Right now, it's cell phones and internet service, but
Yeah.
what
So
if something new comes out?
yeah. So kind of to kind of explain that point. So the fee that's passed on to consumers eventually was for universal service but I think it's defined. It's got to be the more than the majority of customers are using that service, and it's got the amount of money that you can provide can only be sufficient
Right.
for accomplishing that. It can't be excessive. So the parties that were supporting the actions of the regulatory body were saying that's sufficient definition from Congress to make it not a non-delegation
Right. The other thing that surprised me was I thought that there would be more discussion around the intelligible principle doctrine. And that doctrine basically says, look, Congress has to basically grant very specific legislative authority. If they don't grant very specific legislative authority, it doesn't meet the intelligible principle doctrine, and then it becomes questionable whether or not the authority is appropriate.
Yeah,
And
that was interesting. Maybe in the latter part of the argument, it came up, and the
right,
discussion was because again, part of this was I thought the attorney on our side did a shitty job,
right,
and he didn't push that. He said we don't need a change in the standard because that's the standard. The idea is this is the general idea. So they're supposed to pass a law, and if somebody exercises their judgment pursuant to the law must be sufficiently defined so that you could figure out if they complied or not. And that's the intelligibility standard.
right.
I think it's a pile of BS, by the way.
Well, I do too, but I will tell you, I thought it was more relatable to MMTLP's situation than Alpine's situation. I'm going to leave it at that.
Yeah, so
But, go
I
ahead.
kind of want to address that. So as I'm listening to it and I'm listening to the questions, it wasn't I agree. I think it's a crappy case. I think it's a bad case for trying to make precedent. One, because there's a statute that apparently talks a lot about it. It's pretty specific.
Right,
Second, the private party. So, comparing it to our SEC case here, like MMTP, Alpine, whatever. In that case, we have a regulatory body being the SEC, and then they delegate to a private company.
right,
Unlike in the SEC case that was just heard, in that case, all that private company did was basically ministerial tasks. They didn't exercise any independent judgment. They
right.
just kind of did stuff. And the question was, could in essence the SEC rely upon it? And if you notice, the court never even asked them any questions about that. Never
No,
even got to that. They weren't even interested in that.
no. What he brought up, and it was Alito, basically said, are there any instances where the FCC doesn't approve this because based on the data, they just rubber stamp it? Yep, that looks
Yeah.
good. Yep, that looks
Yeah.
good. Yep, that looks good.
Yeah.
So obviously my brain is thinking MMTLP and not really Alpine. And this is where I struggled. And maybe you can clarify how you were kind of relating it. But, the intelligible principle doctrine really doesn't come up with Alpine. What's coming up with Alpine is the SEC basically absolved, or FINRA basically absolved the SEC from doing their job here by not involving them in the expulsion hearing. And that was the crux of the case, which is why the Circuit Court of DC said, no, you need to involve the SEC. The SEC needs to make this decision. Your function is more administrative. And you're going beyond that by making this decision and not including them.
Yeah, well, the way I looked at it, it's kind of, so one aspect, FINRA was delegated by the SEC with the responsibility of managing brokers, capital dealers, and the like. And obviously, they have the ability through contract to impact certain exchanges, as they have undertaken that we're aware of. And that's not monitored by Congress. Zero. It's zero. And it's not a ministerial act. A ministerial act is, like like JR was describing, like a rubber stamp or something that really doesn't require considering and making a judgment on. Just a signature or whatever. Just that it requires that to complete the transaction. In MMTLP, and we haven't even gotten there yet, but in MMTLP, obviously, FINRA interjected themselves and there was no supervision. They acted independently. Congress certainly didn't consider that. And as far as I know, nobody's cited to this. There's no legislation that I've ever seen that gave FINRA that power from Congress. Nothing.
Stop
Doesn't exist.
Stop talking. Stop talking.
We're done?
We're done. Stop talking.
Okay. That seems to be. But when I was listening to it, maybe you could kind of think of it this way. When I was listening to the hearing, besides, again, how bad the attorney was, I was listening to the conservatives' questions. And again, the way this is kind of odd to me. If you look at the questions before the court, they're purely non-delegation questions.
Well, that was the other thing. I didn't get the opportunity to review what what issue was before the court. I just went right into listening to it.
3 issues, all non-delegation, all of them.
Yeah.
It looked at could they do it to the agency? Could the agency rely upon a third party? Was the combination improper? It was all non-delegation, but the case itself was a tax case, in essence. In fact, that's what the attorney, our crappy attorney for our side, he basically said, taxation without representation. That was his pitch. And the judges kind of, and I couldn't even see him, by the way, because I'm listening to them. But if I could see their faces, it would be like this. Huh?
I don't think he made the best argument he had, to be honest with you.
I think he did make the best argument he had, but it was a crappy argument.
Yeah,
So kind of what I wanted to address was, I'm listening to this, and I'm listening to the questions of the conservatives about the non-delegation. What was there? There was questions. I think even from the liberal justice kind of said there wasn't even a full delegation of responsibility. They were talking how much is there a delegation, or does Congress retain some part of it? And in this case, there was a delegation, but a very specific statute that dealt with this specific issue.
Right.
And again, the private party, who's outside, obviously, Congress, was not exercising judgment. Nothing. So I'm thinking about this. In our case, the SEC. So let's historically speaking. The SEC comes into existence 1934 after the Depression. It comes in, obviously, Congress at the time existed. Obviously, they didn't know what they were doing. Obviously, I would say they still don't. But be that as it may, at the time, they didn't know what they were doing. So what do? They created the Securities and Exchange Commission. That's supposed to kind of monitor and keep the markets in check and protect investors. At some point in time, FINRA replaces another fallen party and assumes the role of being solely responsible for the punishment and regulation of the brokers, the capital markets, etc. Nowhere was that delegated from Congress. Nowhere does Congress say there is a provision that talks about that you could hire employees, but it doesn't talk about private parties, and it doesn't talk about the issue about whether you have to supervise them or not.
It's under the Maloney Act. The Maloney Act is what created the SROs, but I don't think, I think, and you and I have talked about this at length, I don't think FINRA has the authority to do what they're doing. and their own members are challenging them. You're seeing that. We're seeing that time and again. So, I think they've clearly overstepped their bounds with their regulatory authority.
Yeah, so kind of, and I know you didn't get a chance to see the opinion from yesterday. We're gonna talk about it, but the opinion that affirmed the expulsion of Alpine referenced Jarkessi in a footnote. It talks about it because it has to say why we're not concerned about Jarkessi. But as I'm listening to what's going on at the Supreme Court hearing, so I'm listening to this case. I think it's a crappy case. I don't think it was the right case. I don't think this setup is great. I don't understand. I actually, as I'm listening to it, I don't know who accepted the case. I don't know.
I was wondering that as well too.
I don't really know which side want this case to be heard because the facts were not great.
No.
But as I'm listening, I think, listen, the SEC 100% delegated responsibility of securing the marketplace. Congress does diddly squat. They totally delegate the responsibility of management of the brokers to a private company who exercises independent judgment, has their own rules, own processes. Note
for that rubber stamp.
That is not like in FCC versus consumer research, where it's just a ministerial. That's an exercise of judgment. And here's the problem. The bigger problem is just using, again, Alpine as an example, a timing example. And we're talking about in a non-delegation, because that's an issue. Can Congress delegate their responsibility to an agency or to a private party? It's the timing. And you've all heard that quote is, that if you don't get justice, delayed justice is no justice, right? That's a term that we've all heard, or some of us have heard. Maybe JR has heard it. I probably have never heard of it. But this all started, Alpine started in 2018. So they had 2018, I'm kind of moving a little bit. 2018, there's misconduct. Misconduct is Alpine, according to what's filed, Alpine hurting for money, which is interesting also, thinking about 2018, 2019. They're hurting for money, but they're spending tens of millions of dollars in legal fees. But that's what it says. They're hurting for money. So what do? They create these fees. And they basically, per account, and there were several fees, but this was the biggest one. Per account, they created a $5,000 a month fee. And they charged you. And if you didn't pay it, they'd go into your account and just take the money. And nobody knew about it. And it was alleged that was something on the order of $25 million, of which Alpine kept approximately $3 million. And the allegation is they needed the money, and that's what they were doing. They got kind of caught. They were told not to do it. They claimed that they had returned all the money. There was an injunction. Unfortunately, I guess they hadn't returned all the money. There was proceedings that went on, started in 2020. So now we're 2 years after the fact, but we don't know what happened before that. Again, not a first-time offender, so probably lots of nonsense. 2020, the hearing starts. It goes over, decided March of 22. Now we're 4 years out. The appellate section of FINRA only took them 3 years to affirm that. 3 years. So we're 7 years out. 7 years. The SEC hasn't even seen the case yet.
Right.
From this point in time, the SEC, or both sides, I guess, theoretically, have 90 days to appeal. They will appeal. I guarantee you they'll appeal, but I guarantee you they're going to file in the meantime. And this is what I told you. I think they're going to file a writ with the U.S. Supreme Court. If these jokers, and I think they're scumbags, by the way, just between you and I, this is my term of art, scumbags who engage in shenanigans. That's my term. So nice. These particular guys who apparently in 2018, 2019 had no money, so they had to impose this ridiculous fee that got them expelled, somehow are are able to spend tens of $millions in legal fees and ongoing. And then what they did is pursuant to the expedited expulsion. So this very matter that I'm talking about, where they were ripping off customers, that got them kicked out. But it doesn't get them really kicked out. It just gets an order kicking them out and a cease and desist order. They violated that, like, you remember the story, like
39,000 times.
Tens of thousands of times. At some point in time, FINRA said, "Oh, that's not good."
Hey,
So they started their expedited expulsion. That's what went up to the U.S. Supreme Court, and that's what their cert is pending about their expedited expulsion. They thought that FINRA should be knocked out of the box completely because it's unconstitutional, and they shouldn't have to proceed any further. But they haven't been expelled yet, so that's an issue. On top of that is this order yesterday. I think it was yesterday. March 25th is the date of the order. The appellate section affirmed the expulsion order, and that's a different order, not the expedited expulsion order.
That's the original one.
Yeah, that's the one that relates to the ripoffs of clients 2022 that they just affirmed in 2025. So that's new, and that actually is an expulsion. So unless at this point in time they move and appeal, they will be expelled, and there's a process, even I think in the order, that tells how they'd wind up, etc. But I would be shocked, wouldn't make sense to me. Some company that's spending tens of $millions in legal fees, all of a sudden I think it's a golden opportunity. I think it's a freaking golden opportunity.
Like we talked about, we think someone is funding their legal fees.
It has to be, or it's not possible that somebody's doing it pro bono.
Right.
And if you're going like filing briefs with the U.S. Supreme Court, if you're doing that, this is not like minor money. This is major money. Right. And the fact that in 2018, 2019, they're basically, out of money, so they have to misappropriate money. It's confusing, but the difference is now they've applied to the U.S. Supreme Court, but on a matter they weren't expelled on. Now they have a matter they were expelled on. If they filed on the matter they weren't expelled on, I would guarantee, I'm sure somebody's working on it today. Right. Honestly, somebody's preparing a writ. It's got to go up, and it would be, the difference would be, listen, we've been expelled. And the argument would be a lot of what was discussed in that Supreme Court case. So what was the issue? We talk about non-delegation, right? So here, the enforcement power and the power to enforce brokers were completely delegated to a private party.
Yeah, but in this instance, though, I thought the first claim, the SEC was involved. The SEC has already given their stamp of approval in the first expulsion. Thought that's what it happened.
No. It has never made it to that. No. This is why that system sucks. This is why I'm saying delay. This is bullshit. The regulatory scheme, complete nonsense. And and Alpine is the example. They haven't got to the SEC yet. We haven't made it there yet.
Even on the first expulsion,
on the first expulsion, we haven't gotten there yet. And the problem is the SEC is it's de novo, which means that they hear it live. It's brand new. It's not like they rely upon the existing record. So the appellate department that just issued this ruling, they don't take new evidence. They don't look at the documents. They look at the record and they make a decision based on the record. And they diverted slightly from what the hearing panel record was. But then it goes to the SEC de novo. They will hear it again. And I told you, and I just, I'll be upfront because I have a new strategy about Alpine, so it doesn't make a difference. If I could help them along, I'm going to help them. First thing I would argue, if I were in their position and I filed this cert to the Supreme Court and we have like a brief to file why they should take this case, 7 years. I mean, I'd say I've been denied due process 7 years. Witnesses' memories are shot. I mean, after 7 years, you're going to remember precisely what happened, whatever. And we're not even at the SEC yet to take testimony. We're
Right.
7 years without that. That's, I think, unfortunately, and it's the spot that JR likes to argue about. There's an issue about the APA, the Administrative Procedures Act, whether it provides proper process because of the delay. 2, there's an issue about the Fifth Amendment due process argument. Is that by delaying the proceedings by that much time, does that prevent Alpine from having a fair trial? And I think it's a reasonable argument because in my experience, witnesses' memories do fade over time, especially if it's not like your main deal. So, if this was all you focused on, you'd remember all the details. But if it's like, something that comes up in the periphery after 7 years, that's gone. So if I were Alpine, I'd argue, amongst other things, no due process. And even if I go to the SEC, I don't get a jury trial. And part of the argument is Jarkessi, which is a case we talked about in detail, was a case before FINRA. And that might be a distinction, but it was a case before FINRA and it was a fraud claim against the broker, and the broker objected, and it was decided by the Supreme Court last year. And the broker objected, said, I have a right to amongst other arguments, but this is what the court focused on. I have a right to a jury trial, and you didn't give it to me. And so therefore you can't rule as you did. And the court looked at it and said, basically if it's a common law claim like fraud, something like that, that it would have existed prior, then you're entitled to a jury trial. And Jarkessi's right. So here, based upon the ruling, the affirmed ruling is they got to pay like $832,000. Plus they got to put up $2.3 million in an escrow account. So the way the FINRA tries to distinguish that says we're private. So we're not bound by the separation of powers. That's what it says in a footnote. And as I'm thinking about that, wow, I take that footnote and I put that into my non-delegation doctrine. I mean, what do you mean? You're free?
Yeah.
I think that's a killer. By the way.
I think FINRA's biggest problem right now is the non-delegation doctrine. I really do. We've talked about this. This organization has ballooned into something that it was not designed to do. I mean, they are acting as an administrative agency. They are an agency. They're promulgating the rules. Sure, they're sending them back up, but the SEC is rubber stamping them.
Yeah, the SEC. If you remember, they only had like 3 administrative law judges in their whole.
And they're cutting FINRA loose and allowing FINRA to act as the agency. I got a real I mean, you and I have both talked about this. There's a real problem. I think Alpine's best argument is the argument that it's twofold. And that's the argument that the judge made in the concurring opinion, the concurring dissenting opinion, where he talked about that, look, they are implementing federal law. They are implementing federal law, and they are going beyond what an SRO was designed to do, which is assist the agency. They are acting as the independent agency here. And it's funny because the court of the majority opinion in that circuit, that DC circuit opinion on Alpine, basically said, well, they aren't administering federal law because the only people that are impacted by the enforcement rules are their members, which I think is complete bullshit. But the second thing they noted was, look, this is what they were designed to do, and it's questionable here because they aren't involving the SEC, and that was the crux of the majority's opinion in that case. But the concurring dissenting opinion, he was done with it. I mean, he all but said they're unconstitutional, and they're acting unconstitutional.
Yeah, I mean, I used to think differently, but now I kind of like thought about it and I looked at the opinion. Again, I think that's a footnote from the appellate section of FINRA that I think, honestly, if I'm filing a brief to say the non-delegation doctrine applies, I quote that footnote. This is what FINRA says. They laid it up. I mean, they literally lay up. We're free. We can do what we want. We're not, because there's no separation of powers. We're not obligated to comply with anything. We could do what we want. I think that's, listen, I think if I'm a justice and somebody's coming in front of me, literally, I'm going to cite that footnote. Said there's a footnote that says that it says you're free, you're not bound by anything.
Well,
you're not governed.
And where
and again,
and
part of it. So one is the delegation of responsibility to FINRA. The other thing is is SEC supervising FINRA. So one, I don't know what they do. Honestly, I have no idea what the SEC does. But the one thing I know they don't do is supervise FINRA. They're nowhere to be found. And on top of that, they don't have enough of their own judicial system to promptly decide these matters. Think about this. They claim, this is not me, they claim that 2018, these guys were ripping everybody off. They're still in business, right? They're still in business.
Right.
And they claim they were ripping it off enough that without considering anything else, they're expelled. By the way, that was their ruling. The ruling wasn't that they had a history and that was because of all the 40 years of misconduct. They said just because of this type of misconduct, because, it presents a danger to the public, they're out. But 7 years later, they're not out.
Yeah.
And the idea of this whole system, and this is kind of where I'm kind of taking it. The idea of this whole system was designed to protect investors.
Right.
The way it is set up currently, there's no way it can be argued that it protects investors. I don't care what side of the idea is, it doesn't provide adequate response in a timely fashion. So, I've thought about, I despise Alpine, really. I despise their history. I've babbled about that on and on. And, I opposed, even as recently, I opposed getting rid of them. And I opposed them being successful in the Supreme Court. Now I'm thinking about it. The way the regulators operate, if the Supreme Court doesn't, because I'm hoping the Supreme Court basically, well, let me back up. I'm hoping DOGE decides that FINRA is unnecessary. That's the first step. That FINRA is an unnecessary expense to the government. I mean, I think this is an easy argument, by the way. SEC is there to do the job. FINRA is doing the SEC's job. Theoretically, if they were doing their job. Therefore, no reason to pay money to FINRA. Buy. Cancel the contract.
Remember, FINRA is self-funded, though. So
no, but they have a contract. No, they're self-funded. They have contracts with the U.S. and all those exchanges. I just terminate their agreements. Buy. We don't need them. They're not helpful. As a matter of fact, again, the whole system's designed to prevent investors. So if you asked people from MMTLP, GME, Alpine, GTII, Mullen, if they've been protective, I think they would say no. I think that would be the response.
And WTO find out.
Yeah, I think they would say they're an impediment, right? Because MMTLP, for example, is a situation that could have been cured if FINRA just cooperated, right? They were the actor. They put in
their job.
They did the halt, right? So theoretically, they must have information that explains how, why, when. Seems like they would have that information if they did it. And if they had information that basically put this issue to bed one way or the other, it's done. There's no reason they haven't been. And, kind of, again, because they get special treatment, and I think that they're unique in terms of their discretion and the amount of power they have. But they really, I mean, I think it's unique. And again, it's because we've seen it many times, how many people have been impacted negatively by them not interceding on behalf of retail investors. And, I'm not going to say it's analogous to like a murder or something like that, but the amount of people that are impacted is substantially more than most crime. And anyway, I don't think that FINRA needs to exist. I don't think they perform a useful function. And the SEC, I would limit their power. I think they need to exist to monitor the markets, but in terms of enforcement, I think that should be left to the Attorney General and the DOJ and let them operate in federal court. And as we saw in GTII, I don't think there's any reason today, no excuse why Alpine should not be in a receivership.
Right.
After all their misconduct, or at least the feds going in, filing an action, I think it's in Arizona, wherever they're incorporated, seek a receivership, get access to the documents, get control over the business. If there's nothing to hide, then so be it. There's a record history of all kinds of misdeeds. What we did for GTII is, I mean, I would say the record is, it's a comparable record. 40 years of misconduct. And, we went into court. We were able to do that. The feds have many more resources, all kinds of attorneys. They don't have to pay, they don't have to pay outside counsel. Let's put these guys to bed. And that's why I'm in favor now of Alpine being successful at the U.S. Supreme Court. I support Alpine 100%. I, in fact, will file a brief in the U.S. Supreme Court. You and I, supporting Alpine's position. However, I might go at it a little differently in terms of how I get to the same argument. Whereas Alpine says they may not, that they don't have the authority, I'm going to say the reverse. I'm going to say after 40 years of not taking action, the SEC and FINRA have shown themselves to be not useful regulatory bodies and not serving what their intended purpose was, and they shouldn't exist at this point in time. Right. As such, that would open the door for the feds to go in and take out Alpine.
Right.
Until that happens. Go ahead.
You're working on that brief by yourself, man.
But until that happens, Alpine's in this state where they can exist. And obviously we've seen that they can kind of keep this going. So I don't believe in the regulators at this point in time. I would urge, and I'm calling for anybody who sees this at any point in time, reach out to Doge, and encourage them to discard FINRA. No, and if they want to look at examples, there's plenty of examples. I've sent them texts and whatever. There's plenty of examples, MMTLP, GTII. There's a litany of companies where the regulators are inept, incompetent, bought off, whatever the reason, and don't need to exist. And we can get better justice by eliminating them in this point. Because I don't think it's going to get better with those guys. I don't think it's going to improve.
Well, I'm hard pressed to think that the folks that are going into the SEC for Doge don't have some kind of understanding of what's really going on. I mean, Elon Musk's, everyone knows he hates the SEC. He has to understand the relationship or lack of relationship between the SEC and FINRA. So they're not going in there with a blind eye. So, I think what we all have been hoping for is that they go in and they start to uncover some of the fraud that's been going on. It's a different type of fraud. It's a fraud against the American people. Not that, the USIAF or whatever the funding source was that was doling out money isn't, but this is a different type of fraud. They're taking our money for themselves, instead of doling out tax dollars to some of these crappy organizations. I mean, they're robbing Main Street. We've talked about that.
Yeah, well, with the SEC, they're getting funded, right?
Right.
And they're getting, the question is, then they get better jobs after that. So we're funding their kind of like training and their increase in lifestyle.
Right.
But it's not just that. And I don't think Doge was set up for this purpose, but I think it's perfectly makes sense. When they were talking about, overspending and corruption, whatever, this is corruption. Corruption that kind of doesn't just impact the government by overpaying, it impacts the public by damage that we incur. And I think those are things that should be included, not just the stuff that directly impacts the government, but stuff that impacts retail traders like this stuff.
Right.
And again, the more that can be pointed out to the people, because apparently, I'd heard this before, and I think I saw it today. Apparently, Doge there's people in the SEC checking out things. Okay, that wouldn't shock me because it's a lot of money related to the SEC. So that shock me? No. But this area of fraud should be something they look at. I hope it's something they look at. And, part of it is, I think, out of self-interest, being somewhat of a cynic, because DJT is shorted and was, there was an issue about it. Seems to be like it's probably, even if it's for the wrong reason, that the naked shorting will be something that will be looked at because it was at least seemingly impacted DJT. And obviously you and I have heard about people that are, related to companies that have an interest, and, we've heard the stories, people that we've heard it from, we think they're credible people, but we don't know how that's going to play out. But it seems like there's enough talk and discussion that somebody's going to look at naked shorting. I just don't know what they're going to do. That's really what they're going to do. What are they going to do? Are they going to really take action? Or are they going to be toothless about it? And that's the part we don't know.
Right. That's the unknown. But I don't think there's any question that we know they're going to take a look at it. I think we can say that confidently just based on some conversations that we've had with folks that it's going to be looked at. Now whether or not, what's going to happen, we don't know. But there's no doubt in my mind it's going to be looked at. I just don't think it was a priority for the administration. But now that they're in the SEC, that's going to bubble up to the top of the list. And what's going to hurt them are these cases that are coming out. I wish I would have had more time today, and maybe we need to do this and then talk about it, is the NWBO case. Yep. The judge denied Citadel's motion for, whatever they were objecting to, discovery or something inside of discovery, and they got over the information.
So NWBO is a small company. I think it's in Seattle. Seattle. And it's a cancer drug company. Right.
Plus the metamaterials case. I mean, that's going to be a big one too. And we know we're going we're anticipating the same fight that we saw in Sorrento and the same fight that we're seeing in NWBO. I mean, I don't know about you, but I'll be surprised if they even respond in the metamaterials case. I'm looking for the judge to have to issue a motion to compel. You watch.
We're going to see it probably because there'll be some more feedback at some point in time. If there's a motion, we'll see a motion.
I mean, I just talked to Junk Savvy here about a week and a half ago and asked her if there'd been any filings from the other side, because, it's federal court. So they have to file the motion to enter appearance. Yeah. I've not seen any of those yet. And we're 3 weeks out and they've not, no one filed motions for their appearances.
Yeah. But I think what's going to happen is again, I don't know, but I mean, my experience would be there's probably interaction and they're informally seeing what they can agree upon. And because there's an obligation to do that anyway, there would be an obligation also you get sanctioned if you didn't do it, because theoretically, I've been in many situations. I object to all discovery and you meet and confer and then you agree. And so that's not an issue. And does a court, the worst thing the court has to look at, if I was a judge, is discovery motions. Incredibly boring, long, forget it.
You draft them.
Yeah, I know.
They should be entertaining and exciting.
It's terrible. So the judge doesn't want to see it.
Put that up and read it.
Yeah, the judge doesn't want to see it, so they want you to work it out. So Northwest Bio, I think Wes is the counsel on that one.
Yeah.
So the way it was, I think what I saw, there was a motion to dismiss filed, and that was denied. Yeah, that was denied.
I just knew there was a motion denied, and they're going to discovery.
I didn't see the order. I didn't see, if it was.
No, I didn't either.
Yeah. So I'm just looking at a tweet. I'm presuming that that's correct. If the motion to dismiss was denied, that means the case goes forward, and then they're entitled to discovery.
I think this was a second. I don't know. I think this was a second motion to dismiss. I don't know what grounds they filed.
No, it could be like, the way it works often is you file a complaint and then somebody files a motion to dismiss. It could be granted, but it'll usually be granted with leave to amend. It means you can correct whatever
Right.
deficiencies that exist. And then you'd file another one. They'd file a second motion to dismiss.
Right.
Then judge would look at that and says, that's enough. We can go on. So that's apparently where they are. Apparently they're we can go on now. And the thought process is now that discovery is available, if in fact there's shenanigans that went on, that those are now discoverable, and that might result in some type of resolution of the case. And that's what I think about MMTLP, by the way. So the reason why I'd like to get rid of FINRA, eradicate them, is I think we'd get access to all the documents.
Sure.
That's what would happen. And that's the thing I encourage everybody to reach out to Doge or whoever. That's what I said. I said, you're in the SEC now. There's a bunch of people. I'm paraphrasing, but we know you're there. You're investigating. While you're there, why don't you just release all the MMTLP documents so people can be made whole? Simple. Right. Be a simple thing. And that's one of the reasons why I'd like FINRA to cease to exist. If nothing else, they should lose their immunity. In this argument, I haven't seen it made yet. I don't know why. Alpine should be asking for the immunity to be removed too. I would ask that too. Because again, that is inconsistent with kind of having any risk, right? They're supposed to be acting in accordance with, not independent of.
Well, I don't think, I've always thought that was a tough argument to remove their immunity. I think the better argument, I know you're going to laugh and shake your head and roll your eyes when you say it, but I think the better argument is to say, no, look, when you act unconstitutional, when you are going outside of your executive authority and acting as the agency, you need to be found, you can be found to be culpable under the Administrative Procedures Act.
But you're not, because you're, okay.
That's right, but they're not.
Yeah.
I hear what you're saying. I think the other argument is, look, when you're acting outside of your regulatory authority, that means it's a double-edged sword, because if you argue the one, you can't argue the other. Yeah. But I think the other argument against immunity is to say that, look, when you're acting outside of your regulatory authority, you're no longer acting as the agency, you're acting as the private organization, and thus you're no longer immune.
Yeah, the problem with that is that then the agency will say that anybody acting is outside. We didn't tell them that, whatever. It's kind of making the agency kind of independent of that.
Right. Yeah. You can't make both those arguments at the same time because they conflict.
Yeah. But I believe, again, my belief all along is they're private. They're not public. So like all private companies, and I understand immunity. Immunity is so that they're doing an important duty. And if they make a boo-boo, it could put them out of business, because we're talking about
only immune when they're acting within their regulatory authority.
Well, that's not what it says. It's because it's overbroad at this point in time. But my point is, it's a private company, like every other private company. If they make a boo-boo, I just bought homeowners insurance, literally, before I went on here. I have to. I have a mortgage. I'm required by my mortgage to have homeowners insurance, because what it does is it covers my risk if the house burns down. Not that in Southern California you have to be worried about fires or anything.
No, not at all.
But whatever. So why is FINRA? Why should they be any different? Why can't those mother effers go to Farmers Insurance and buy a policy? And if they goof up, okay. And if it's designed to protect retail investors, then getting insurance is a positive, not a negative. There's still no risk, nothing that's going to put them out of business, nothing that's so big, but then everybody's protected, and then there's no reason also for not being open and transparent.
Right.
So people like at MMTLP can't have access, or us, Alpine, also the same thing, and GTII. Come on. There is a long record of stuff. Why don't we have access to the long record of stuff in the decision making? And kind of like even this affirmation made me think, is it because we're bitching so much that they looked at just the one act, right? I think I mentioned it to you. They didn't look at their history. They just looked at one act, and that was enough. Was that because we were bitching so much that
Right.
they didn't want to like look at the prior? They want to like independently determine that. The other thing that was interesting, and I know we're kind of all over the joint, but I think this is an all over the joint conversation because it's kind of, we're just kind of talking about issues that might arise. In that opinion that affirmed their expulsion from 2022 that was issued March 25th, they talk about so they're trying to say why they kicked them out. And, why did they kick them out? Because they said the offense was so bad that they had to kick them out. But before they do that, they look at mitigating factors and factors that might not be mitigating. And mitigating factors, they found zero. No factors that mitigated. There was no reason not to kick them out. And aggravating factors, they looked at their history. But they didn't look at their entire history. Like I were them, or would it be like my first stop, pedophilia city, right? That, whatever. I kind of like stop at that because that's something that catches your attention. It does. It really does catch your attention. Where they stopped, and the only thing they mentioned was the 2019. No, I think it was 2017. No, 2019. U.S. action where they didn't file the SAR, so there were those suspicious activity reports. So, and we've talked about them in our videos. I mean, multiple times. Because I thought it was like, it was there to avoid terrorism and yada, yada, yada. And these guys for like 4 years were just, we don't have to file them, or we'd have to file them accurately. We don't have to discuss them, whatever. And they were only looked at for 2011 through 2015. They weren't looked at 2015 to the current time frame. They never looked at. And the government didn't take action till 2019. So in this affirmation, and we would not have known, I don't think we would have known this otherwise. When they're talking about the aggravating factor, they talk about the SARs. And instead of terrorism, what they talk about is a bunch of activities involving basically misconduct involving microcap stocks.
Right.
They say like there's, thousands of these, and they involve microcaps, which in my mind is illegal shorting. That's what they're concealing.
Right.
We don't know what happened after 2015. We don't know what happened to the current time frame. We know they're spending millions of dollars in legal fees. We know in 2019 they had no money. How are they generating that money? How? I mean, if I were the feds, I'd make them show me. Makes no sense.
Right.
How do you prove that if you have no income? I mean, if the IRS was not so incompetent, and if an individual, let's say they make $50,000 a year, but they show they spend $500,000 a year, that might catch somebody's attention. And in this case, their business does not match their expenditures at any point in time.
Right.
And we know by this new information that they may have engaged, because we know, we saw the concentrated short position at some point in time. That was after 2015, by the way.
Yeah.
So I think that's something that could be looked into. Again, I think it should be done in court, not through the regulatory system. And I think it would be much quicker. The appeals would be cleaner, and the arguments that somebody could be made by like Alpine are much less. You just eliminate them. Give them a jury trial. Listen, this is not a criminal proceeding, so you don't need a unanimous jury. I feel comfortable that a reasonable attorney could establish fraud. I feel comfortable with that and get a jury to figure that out.
Sure.
Get these guys out of there. And beyond that, this is like the bigger point. I was going to use a bad word that started with a P, ends with a Y, describing the government's actions to date. If they just picked a couple of these guys and completely eradicated their businesses, let's see if everybody is not getting in compliance after that.
Oh, for sure they will. So
I mean, I think they have to literally decimate these companies, put them out of business. Done. I mean, I no harm. I'm not talking about physical harm, but let's close these shops down.
yeah,
No reason to keep them open, and use these guys as examples. Let everybody think that, if they came for them, they can come for us. I really feel strongly about that.
right.
Okay.
So Brett had a question. Brett, no, FINRA was not created due to an executive order. It was the SRO model was created under the Maloney Acts of, I think, 1938, which was a very large amendment to the Securities and Exchange Act of 1934. FINRA was actually created by regulation because it was two SROs that were doing the same thing were combined back in 2007 to create FINRA.
Yeah.
So
yeah. So they exist, but again, not till I think they actually didn't exist 20 years ago. I think it's the last. They're at least in name, in name only. Any other questions, by the way, or anything you want to add? Anything you want to disagree about?
No, I think you're spot on with everything. It's going to be curious to see how this next round with Alpine plays out. But like we've talked, I'm just looking at a question I can't think of.
I would, actually, if I was Alpine's attorney, let me counsel Alpine here a little bit. I'm your attorney here today, looking out for your best interests. I think so. The court doesn't think like you're being a dick. Why don't you withdraw your cert as to the expedited expulsion? Withdraw that. I don't think because I think it's a bullshit argument because you haven't been expelled yet, and then file your cert as to the actual expulsion.
Yeah,
that's what I would do.
Yeah, there's really no other questions out there other than Brett's last question. I scrolled through them, so yeah. I mean, look, it's going to be interesting to see how this one plays out now. So
yeah. Again, I'm expecting Alpine to jump in, go forward, and again, I support Alpine 100%. So they can get expelled. That's why I support them 100%. And I think, I urge everybody out there who has a voice, contact Doge, really contact Doge, and whatever, you're interested in, let them know that's something they should look at. And it, like anything else, if there's enough response, it'll catch somebody's eye.
Yep.
And again, we know that DJT was shorted, so it's an issue that somebody around DC is probably aware of, and even if they're not like interested in our tickers per se, if they take action, it might impact our tickers also. So let them know, and it's the more the merrier. Be nice about it, be succinct, but be consistent and persistent.
Yep.
That's my 2 cents. Anything else you want to add?
Nope. That was a good show.
Okay. Anyway, thank you everybody out there who hung around and listened to this garbage today. If you have questions, obviously afterwards, please ask them. And, to the extent we can answer them, I try to answer them if I can. A lot of them are just too hard for me and beyond me, so I just can't answer them. And JR is no use, by the way.
Never.
Most times. But anyway, thank you all for listening. If you have questions, let us know. Hope to see you again soon. Be well and take care.
Okay. Bye.